Good morning everybody, and thank you for joining us for the third of our Litigation Lessons series. Today we're going to be talking to you about break clauses. For the keen-eyed among you, you'll notice I'm not joined by Ellie Claffey today, but instead by Bradley Powell, an associate from our commercial property team. So thank you, Bradley, for joining us today. Just to give a little overview of what we're going to be touching on our agenda, we have basically an introduction to break clauses. We'll then be touching on what we would normally see in a break clause, the contents of a break clause. We'll touch on break notice traps, and in particular, the ones we see more commonly: vacant possession, serving of written notice and issues around that, and rent arrears. And then finally, we'll just have a little summary giving you a series of break notice tips. So we'll start running through. If you have any questions, by all means, please type them in the box and we'll try and deal with them as we go through, if we can. If not, at the end of the seminar, there'll be our contact details and our email address, phone number, etc. So by all means, make us an email afterwards if there's something you would like us to come back to you on or to discuss. I appreciate that not everybody wants to air their, as it were, business on a public chat site, so thank you for that. So without further ado, I will hand you over to Bradley. Bradley.
Good morning. Thank you, Graham. Thank you. As Graham said, my name is Bradley Powell. I'm an associate solicitor with the firm in the commercial property team. I deal with commercial property, and particularly commercial property leases, pretty much on a daily basis. That means that certainly for me, break clauses are a very relevant topic, and look forward to talking about them. So following the slide then, firstly we're looking at what is a break clause. I might be explaining something to you that you may all be aware of, but the definition of a break clause is it's a method of terminating a lease that's exercisable by either party without penalty. So what this means in practice, your classic lease will have a start date and an end date. A break clause is a clause that's inserted into a lease, in, as I say, the majority of cases at the moment, which will allow one or other of the parties to terminate prior to the end date. Types of break clause then, very, very briefly, and I think this is something that will be repeated through the remainder of the talk. For the purposes of today, we're looking at three different types of break clause, and it depends which party has the right to exercise it. So you have leases which have a tenant-only break clause, clearly exercisable only by the tenant. They're the most common type of break clause that I see. And then you get some leases where there's a landlord-only break clause, again, exercisable only by the landlord. They are pretty rare. They only really tend to crop up in situations where the landlord anticipates before the start of the lease that there may be a circumstance where they're going to need the property back before the end of the term. I see quite a lot of those when I deal with leases of railway arches. That's a common example, but also might crop up if a landlord was looking to redevelop. Lastly, and unsurprisingly, given the previous two, you can have a mutual clause, which means that either party to the lease can exercise the break clause prior to the end of the lease. So how do they operate then? I'll use a typical example through my part of the talk, which may help. Say we've got a lease of a retail unit for a term of 5 years, and it allows, in our example, shall we say, the tenant only to exercise a break clause on the 3rd anniversary of the term. So Graham might correct me later. I don't think there's any particular legislation, but the lease itself will set out how a break clause will operate. Certainly, there are some fairly hard and fast rules. In particular, I've never seen a lease which has a break clause which didn't expressly state when the break clause had to be served, by whom, and the method of service, which is almost, well, it's invariably in writing and to a specified address. Could we go to the next slide, please, Graham? Thank you. Timescales then. This will vary. Quite often there'll be more than one break clause in a lease, but the timescale for exercising a break clause will again be what it says in the lease. Commonly, this is well, for most leases I see, it's generally a 6-month period. And if I can go back to the example we were using a moment ago then, where we've got a retail unit for a term of 5 years, if the tenant did want to exercise the right to break on the 3rd anniversary of the term, if there's a 6-month notice period within the lease, then the tenant would have to serve their break notice before a period that's 2 years and 6 months into the term. Generally, and Graham will come into this in more depth, time is of the essence on those types of clauses. So if the tenant misses his 2 years and 6 month deadline, then he won't have the option of exercising the break clause. As the benefit of the break clause, again, this is touching something I mentioned a moment ago. Again, it's going to say in lease, so it's going to be one of the parties to the lease, either the landlord or the tenant, or either party. Lastly, on this slide, then, and probably the most substantial part of it, is conditions. You can have unconditional break clauses where a lease will say on such a date either party can break the lease, but that's very unusual. The conditions are something that are generally negotiated by the parties beforehand and have to be inserted into the lease. I know, just going by Graham's introduction, that he's going to be touching on some of these in a moment, but your typical conditions will be that the party exercising the break will have to serve a notice in writing by a particular date to a specified address, which commonly will be a registered office or a place of business. And then in particular for a tenant, the tenant will wish to limit the amount of conditions that are put on to the exercise of the break clause. But generally, a break clause from a tenant's perspective won't be exercisable if, for example, the tenant is in arrears of rent as at the break date, or if they can't give possession back to the landlord free of occupation. Excuse me. There are other conditions. I'm dealing with a lease at the moment where the tenant, if they do wish to exercise the break, they'll have to pay a certain set sum to the landlord as well. But they're your classic conditions, and that's the introduction and content to break clauses. I'll now hand you over to Graham.
Thank you, Bradley. So, from the litigation perspective, as it were, Bradley drafts them, and then normally when it comes to exercising it, it comes over to the litigation team. Now, I suppose to begin at the beginning, break clauses from a litigation perspective are interesting because although they're recognised as being completely legal and a commonplace feature in a number of leases, generally, I think it's fair to say that the law around them and sort of how they operate, that they're very dangerous, I suppose is what I would say. They are something to be taken incredibly seriously. The courts don't seem to really like them, albeit that they actually recognise them as being legitimate. They sort of tend to really sort of get into the detail of them. I think this is really because the law obviously is trying to give certainty. The law generally is grown up to, we have a contract that's meant to bind everybody. And so the thought of giving one party to that contract the opportunity to sort of just walk out of it it's not really an alien concept, but it's something that is not treated lightly and is given a great deal of weight. And I think basically, I suppose all I would say with these is, and as somebody's often left, as it were, with a sharp end to actually exercise them, they are often not given enough consideration by the party that actually wants to exercise the break. As Bradley says, traditionally, usually 99% of the time, the tenant. And so we've talked about, the timelines, the deadlines that are in the break clause, and will often get approached in regard to them, sometimes with just sort of very, very sort of short and urgent periods to run and make that happen. So it could be, I've had a phone call a week before the deadline, and, sort of, I suppose all I would really say, and the reason I'm sort of labouring this a little bit, as we'll run through with my slides and some of the examples that I give, are that this is an incredibly serious sort of undertaking, and it's much, much better to give it a great deal of preparation, almost from the moment you enter into the lease. You should really be thinking about, how if you're going to exercise the break clause, how you're going to sort of, I suppose, gear yourselves up to do that. As Bradley's also said, often these are, relatively early on in the lease. You can get them where they're sort of after 2 years, after 5 years, after 7 years, if you have a lease that long. But I appreciate leases traditionally are sort of getting shorter in length from when I first came into the law, where they would be 25 years, 30 years. So again, with this sort of change, it's all the more important that you're geared up and ready to go. Now, my first slide, break notice traps. I quote Lord Hoffman, sorry, let's have a little drink, from the case of Manai Investments versus Eagle Star from 97. And what he says here, and I think this is really the most, this section is the most important of all the sections to remember. If the termination clause, the break clause, had said that a notice had to be on blue paper, it would have been no good serving a notice on pink paper, however clear it might have been that the tenant wanted to terminate. The point being, the courts are looking at the detail of each notice. The expression, the general wish of both parties could actually be that that they know that they know that the tenant wants to terminate, this is coming to an end. But if the tenant does not, or the landlord, if it's their clause, if they don't abide by the detail, then they are still going to get caught out. So I'll come on to sort of more details, but it may be that you have to leave the premises with vacant possession. It may be that you have to serve the notice at a particular address that has nothing to do with any of the other parties. It could be almost like an agent's address in London. It could be that you have to serve the notice at 2 addresses. It's got to be served within 6 months. It's got to be on blue paper. All these things have to be complied with, and I suppose, therefore, the earlier, as it were, you deal with it, the earlier, if you need lawyers, we're instructed, the more time it gives you. Even these days with the post and service of notices, it's no good just saying, oh, I'll pop it in the post and it should get there. Often there are delays, or there's a gearing up to it, and things need to be done. It may be, as is often the case, you need to, repair or carry out dilapidations, ready the property for your departure, in which case instructing 7 days before is going to pose problems. So all I would say is there must be strict compliance with any conditions that are in the lease, and they can be very abstract, although the normal ones are, it operates within a period, it's got to be given by a set date, it's got to be given to this address and in this way. You do get some strange ones, and they're deliberately drawn in that way to make it as hard as possible for the tenant often to get out. So my point really is, abide by the strict terms of the break clause, but please, please, please give yourself ample opportunity to think about it. And that even goes in regard to exercising it. The times I have had clients come to me late and say, I want the break. And I've said, you've got somewhere to go, have you? And they've said, well, no, but we're just about to sign, a new lease, or we've got something in the pipeline. And then it falls through. And as I'll come on to, once you've exercised, you're almost having to throw yourself on the mercy, as it were, of the other party to have the lease carry on. So everything around a break clause, although they seem relatively innocuous, I can break after 2 years, they really are dangerous, and they need to be given proper consideration. So let's look at I've focused, as I say, on the 3 sort of main areas that we see. So vacant possession. So again, just to be clear, and again, forgive us because we have to pitch these talks at a level where some of you are experienced, property portfolio managers will probably know this. Others who, are watching and have just gone into perhaps commercial property won't. But vacant possession means just that. You give it back to the tenant completely vacant and effectively empty. So the property needs to be, and again, I've summarised it, but free of rubbish, free of any goods, free of any possessions, free of people. Come on to that and what that means. Any additions, the partitioning, mezzanine floors, signage, you need to make sure that that's all stripped out. And again, there are more issues around things like return of keys, security passes and key fobs. If that is all detailed as something that needs to be, as it were, you need key fobs given back, you need to have access to the property. These are all things that will come in terms of a vacant possession and giving access to get back in. So again, as I say, if in doubt, get it out, but at least take legal advice on it. And obviously, if you are going to exercise the break, you can reach deals with the landlord, or if you put in a mezzanine, they may want to leave that mezzanine in and be happy to sort of do a deal that it's left in. But I think the problem is, going back to my 7 days, it's very unlikely that you are going to get an agreement, as it were, at that short notice, unless these things have been looked at. And often as well, I mean, again, Bradley's here, but it will be very useful to actually have this documented in writing, and I'll come on to some cases or touch on cases around that. But it's no good often just having a discussion with the landlord says, yeah, that should be okay. You'll find that then when you've exercised the break clause and she comes back and says that's not okay, you're then effectively stuck. They argue the break clause won't apply, and this is the point really. If the break clause is not deemed to apply because you haven't exercised it within the realms of the lease, then the lease carries on. And if it is, going back to what we're saying, sometimes you only get one opportunity to break after 2 years, then you might be, with the property for the remaining 4 or 5 years. You don't really want to make any errors sort of around this. So we need to be careful. So just some juicy cases really that sort of illustrate this point. NYK Logistics UK versus Brand Estates BV. Forgive me, I've tried to make these slides sort of detailed as possible because I'm conscious not all of you will be exercising your break clause at the moment. So you sort of can keep these and touch on these as appropriate when you need. But in this scenario, the tenant was deemed not to have given vacant possession. They had further discussions with the landlord in regard to remaining in the property and in regard to carrying out dilapidation repairs, but these were just discussions and nothing was formally agreed. When it went to court, basically the landlord challenged that the break clause had been exercised properly because the dilapidation works were still going on, and effectively the tenant had sort of vacated but left workmen in carrying them out. And here the court basically said it's irrelevant that the tenant had no intention of excluding the landlord, i.e. he could get in and out as he wished, or had no intention of continuing to occupy the premises. That basically, as it says here, that there was basically a holding over, vacant position in full wasn't given, and so therefore the break clause wasn't exercised properly. And again, as I said, about going back to getting a proper agreement, the right thing to do would have been to reach an agreement with the landlord to enter into a short-term license, which would have effectively given possession back to the landlord, but given the tenant the opportunity to come and go to sort out the dilapidations. And there's obviously a lot here. The landlord was able to get back into the property. Vacant position wasn't given in accordance with the clause, and so even with discussions in the absence of anything formal, the whole thing fell down, and the tenant had to remain in situ. The break clause opportunity had been missed. And so going on to here, just thinking point, do not rely on verbal agreements or handshakes with the landlord. And again, this is the best thing to do really, rather than mess around entering into a license, before, but after the event or when you're in the middle of looking at the break clauses, give yourself plenty of time to sort of work through this. Often when I'm approached about a break, obligations, other obligations in the lease, such as dilapidations, haven't even been looked at. And often from a litigation perspective, we'll say this is the issue, and they say we'll get on and do the break, and then we'll look at that later on. So give yourself plenty of time. Vacant possession too, and this is again hybrid versus MYK, which you notice is the same case as it were, but with the names reversed. This is because it went to appeal with the tenant effectively challenging. And again, this is just to clarify more of the same, really. The tenant vacated, as I've said, but workmen were allowed to stay on for a few extra days to carry out the repair works. And again, the point is I mentioned as part of vacant possession, the people aspect. Just to be clear, the place was cleared. It was workmen, repairmen, ladders, paint, that kind of thing that were in the property. So just because you've cleared out, it just shows how strict the court is on this. Vacant possession is everything out. Riverside Park Limited versus NHS Property Services Limited. The leaving of demountable partitioning, kitchen units, activated alarm systems, key fobs, and floor coverings in a property. So all pretty low-level stuff, the kind of stuff that I suppose as a tenant you'd expect the landlord to go in and just put in a skip before they perhaps, put the property back out on the market, or perhaps even offered it with that in and asked, whether the tenant wanted anything, done, or whether they were happy to take it with those items in. Basically, they were left in here, and again, the clause said that vacant possession had to be given. Court's viewpoint was, quote, no room for general considerations of fairness or conduct. So what was reasonable was irrelevant when assessing a break clause. The break clause and the terms of the clause, the conditions, as Bradley said, have to be satisfied. So again, just an illustration of really what would be seen as relatively light, minimal issues, but still fell down. And what you think is reasonable, doesn't count. It really is incredibly strict. If in doubt, the landlord, as we've said, but my view is beyond your game from the very start.
We have a question in there, Graham.
Oh, okay.
So, could you include repair provisions in the break clause itself, especially where a lease allows for fairly substantial alterations in the first instance?
Drafting,
absolutely.
Yes.
Yeah, if there is anything in particular, it's the sort of thing you should think of in advance, and particularly if you're looking to carry out alterations to the property. Absolutely, yes. Anything you want, as Graham's mentioned, it's best to have everything you want in that clause, so that there's no confusion and you have total clarity as to how the break clause will operate when the time comes. Thank you.
Yes, I mean, just to back onto that, on the basis that you got, Lord Hoffman saying that if it's on blue paper, it needs to be on blue paper. I mean, a rent clause almost seems reasonable, as it were, but a repair clause seems reasonable. So, and these are deliberately made sticky, so that the tenant has to do a dance to get through it. So, thank you for that. Serving of notice, and this is often, to be honest with you, the biggest and most common one we see, primarily again because we haven't had the lead-in time or the prep time to do that. But again, the devil is in the detail. The clause will explain and be quite express, and the lease will obviously build on this as to how notice is to be given and the provisions around that. So again, looking at this, things just to consider really. Make sure you serve it. This sounds so obvious, but I just see it so many. We have so many legal cases on this. Make sure you serve it on the right address. In terms of receipt, again, unless this is set out somewhere in the lease, normally the landlord, if it is a tenant-only break, which is then 99% is, if it's a tenant-only break, the landlord does not have to acknowledge receipt. Obviously, you can ask them, you can put in your covering letter, please acknowledge receipt. But in my experience, they deliberately don't, because they'll often take legal advice and then come back as to what is there. So, again, the wrong address, and then obviously no sort of right to be told that it has landed, can lead to more problems. Bradley's touched on this as well. Please make sure it's within a timescale. These normally have to be exercised by a specific date, which you'll appreciate going back to what I've already touched on with post, or even, courier delivery, or whatever you want to do. There are always issues, as it were, that can creep in. So really, we're wanting to execute, the break clause, giving ourselves plenty of leeway. It really is one way you sort of want to do it, to give yourself plenty of opportunity for the postman to get it wrong, or to double check these things. So really, as I say, preparation is key. And then other just things that we've seen: ensure the notice is served in accordance with the terms of the break clause. Questions to consider: does it need to be served to the landlord or agent? And I've seen them where they're actually served on somewhere else. I had one recently involving a Scottish landlord, not strictly relevant, but we had to serve on an agent in Glasgow, despite all of the property being this way. So that was sort of one of those things where, I mean, don't get me wrong, once we've read it, it's there, but the client hadn't even looked at that, if you see what I mean, to see how that would be affected. And obviously it wasn't one where we could just send the trainee solicitor around to sort of pop it through the letterbox. We had to sort of look at couriers, and that in itself took some time. Is the landlord the same as stated on the lease? Now, often you'll have the landlord will sort of either could pass the lease to a subsidiary company, could sell it effectively to somebody else, but the lease sometimes isn't necessarily updated. It effectively just transfers all the provisions over, and in that situation, I suppose my view would be do a belt and braces. We would serve it on absolutely everybody with a pulse to make sure there is no comeback. So the old landlord gets one, the new landlord gets one, the agent gets one. The property from which the lease, the property to which the lease relates, even gets one. We would blanket everybody, and that may be extreme, but again, I think it shows how seriously we take those. How should the notice be served? Fax, post, email. I've already touched on there's no right to ask the landlord to acknowledge receipt. So really, not only do we have to get it right, but ideally we do want to put a read receipt or a delivery receipt on it if it is an email. We have to normally serve under the terms of the lease in terms of the notice provisions. These are often in line with Section 196 of the Law and Property Act. So again, that can be by a form of registered special delivery, which may give you comfort in that you stay to the post office and they then deliver it. The only thing I would say on that recently, and you can tell I'm a man that's jaded, is when we then log on to the post office, and again, the post office is a wonderful institution, but when we log on to the post office to see whether there has been delivery, the website will just simply say something like, pending, as it were. It doesn't say it was delivered at this time, and I'm sure if you need to drill into it, sorry, I'm not sure at all. I would imagine if you want to drill into it, there will be some record, as we all know from the deliveries we get. The postman does take a picture or will log it, and if it's an Amazon delivery, we normally get an email within a few seconds of their delivering saying that it's come. But having said that, we've served a few things, and that website gives us absolutely no comfort at all. So sometimes with these, I would sort of advise, taking photographs, keeping the post office paperwork, the certificate of posting, and obviously as much as you can around this to make sure you've got some record. And then finally, are you sending the notice from the correct company? And I've touched on that a little bit before about there being subsidiary companies or changes of name or just general changes. And again, just to give you some sort of relevant examples, Hexstone Holdings break notice was given by a parent company of the tenant company, so in other words, not by the tenant. Break clause said it had to be given by the tenant as a party to the lease. No evidence that there was any anything given to say the parent company had authority to serve it on the tenant's behalf. The lease didn't allow that, and in those circumstances, the break notice was deemed invalid. These always seem sort of very sort of primitive examples, but it's just one of those where in the hubbub of it all, sometimes we'll look at the original lease or look at the change, and it's not always clear with the paperwork that we're given by the client, even though we check this. So again, this process of preparing is relevant. Claire's Accessories versus Kensington High Street Association. Again, the break notice here was served on employees at the leased premises, so not at the registered office or the address that was, as it were, specified in the lease. And so again, the lease specified had to be set at the registered address of the company. Break notice was deemed invalid, and so it continued on. So arrears. Now, this may seem very obvious. It stands to reason, doesn't it? You're not going to let a tenant out of their lease and the obligations under their lease if they owe you money. But it can go a little bit wider than this. So arrears may not just be rent. Sometimes under the definitions in a lease, service charges are deemed as rent, insurance is deemed as rent, interest on rent is deemed as rent. Often rent is ascribed as it were as any money sort of owing between the parties, the tenant and the defendant. So again, pay attention to this, because we'll often say to the client, is everything paid up? And the answer is a categorical yes. But then there is an issue that comes back later from the landlord. Oh, what about the service charge? What about this? And we will normally try and cover it off. In terms of the lease, if you let us have a copy, we will write and say, well, rent is defined as this is all up to date. But again, this is an example, Avocet versus Merrill. Landlord claimed a break option was invalid as the tenant had failed to pay default interest on late payments under the lease. And just to explain, in this case, because the tenant knew that it was coming up to the lease date, it had effectively sort of held back rent and then had served as a paid the rent by a cheque, which obviously doesn't clear on the day that it's presented to the landlord. And it presented it the day before, again, sort of lastminute.com, the day before the break was to be exercised. Now, that cheque was accepted and the landlord didn't jump up and down and make any fuss about it. But then later on, 3 months later, after the property had been, the tenant had carried on vacating, etc., it said that there had been an issue with interest because the rent had effectively been paid later. It was 6 months' rent that it had missed the payment, the original release payment date. And the fact that it was then served the day before and by a cheque, the cheque didn't then clear for another, whatever it will be, 3 clear days, I still think. But again, we know that can have delays as well, anything involving a third party. And the tenant, jumped up and down, no default interest had been demanded by the landlord. But when the judge got into this, he said, well, it's not up to the landlord to make sure this is all up to speed. If you're exercising a break notice, you need to get your act together, and effectively, by not paying rent on time under the terms of the lease, default interest was chargeable. And so you're in breach of the lease because you haven't paid everything out. The lease couldn't be validly exercised, and again, the tenant was trapped. So I'm just throwing these in because it is that, going back to the Lord Hoffman blue notice, blue paper, it is that finicky. So factor that in. Another example, PC investors versus cancer research. Condition for tenant to pay rents reserved and demanded up to the termination date of the lease. And the rent was payable, in this case, the key point is payable on the usual quarter days, which I'm sure you're all familiar with. But anyway, so basically the tenant in this instance, knowing it was going to exercise the break clause, had apportioned the rent, so rather than a quarter's rent, a quarter's rent, a quarter's rent, it effectively only paid to the end, as it were, from the quarter date to the exercise of the break clause. And so the landlord argued that the condition hadn't been satisfied as the full amount of due that was paid, i.e. 4 quarters rent, was in arrears, and so the break can be exercised. And again, the courts upheld this. Unless the lease states that apportionment can be made, you must pay in advance and then look to get the credit back after you've exercised. And these, going back to sort of everything we've touched on today, doing exactly what it says on the tin versus what a tenant might think is reasonable in all the circumstances. That you have no leeway on this. It is black and black letter law. There is black and white. So break notice tips, and again, I'm just really running through kind of what we've already sort of touched on. Please take it very seriously and prepare. I don't blame tenants for this at all. I can almost imagine, it starts out as a bit of a discussion. We might want to move premises, or we've got that coming up, we might need to expand. And it's driven, isn't it, 9 times out of 10 by business needs or business challenges. But as I've said at the top of this, I think you need to almost diarise this from the moment that Bradley tells you that the lease has been completed. You need to almost write somewhere, make it clear that the break will need to be exercised if you're going to by that date. And as we've just run through, what steps would need to be taken to get you there. So if you are having to make good the property by way of delapse before you leave, you need to factor in sort of what would be a reasonable period of time for those dilapidations to be carried out, so you're not left in the position that we've seen where you've got workmen on board not giving vacant possession and you're having to enter into a license to agree this. As I say, diarise the breaks and the notice periods to ensure you give yourself sufficient time to repair. Touched on that, obvious. Consider the conditions of the break option, including conditions relating to service of the same. Again, more of the same, really. It's one thing to diarise it, but you do have to work out sort of almost like a countdown what you need to do and how long that would need to be taken. And obviously, the more onerous the terms, the more time you will need. Think about what needs to be done before the break date. So again, same old, dilapidations, remove the tenant works, ensuring all payments are up to date. Do not leave these to the last minute. Once a break notice is served, and again, I mentioned this, it cannot be unilaterally withdrawn. You've nailed your start to that wagon. There is no way back. It is as it is. So please make sure that you know exactly what you're doing and you've got your ducks in a row. So like the god Janus, you're looking back at what's to come before it's happened, but you're looking forward at what's to come, and you've got to get your new lease lined up and signed and make sure your ducks are in a row. I have seen it where the tenants throw themselves on the mercy of the landlord, and the landlord might be struggling to get a new tenant in, or might be happy to work with them.
Yes.
But of course, that does lead to arguments that the lease is back on, or so it's even if you go back in. My point is, it's worth speaking to someone like Bradley in the commercial property team, or myself, the litigation team, just to make sure that you have sufficient paperwork to show that it's not almost the granting of a new lease or back on the old terms, or you've waived the break. There is no obligation on landlord to acknowledge receipt of a break clause, and I've talked about that. You often get a landlord say things like, they'll acknowledge receipt, but without prejudice to the validity of the break clause. So in other words, we received it, but we still don't accept you can do it. Not that they don't need, sorry, that's even going too far. It's not that they don't accept that you can't do it. They're just nondescript, non-committal on it. And we've had a few moments like that where the tenant sort of feels in limbo. And I suppose that's the downside and where these problems come in. I'm saying look ahead, but at the same time, do you want to look too far ahead, sign up to leases without knowing you've necessarily got out of the last one? Again, all of this needs meticulous planning, as we have said. And then finally, just a touch on here, proof of posting service is always a winner. If you take it to the post office and you get them to do it, they should be able to give you a small receipt showing obviously what you've paid, but also what we call a certificate of service saying that they have had it. Some of my clients, as a belt and braces, will actually employ a process server. It's around 100 to 150 quid plus VAT and pop. But at least in that way, you've got it hand delivered. If the terms of the notice will allow you to do it. Sometimes it'll just say by post, in which case you may make a run for your own back if you don't comply with that also. But at least, what I'm saying is create evidence. And finally, photographs. If it can be hand delivered, take someone with you and take photographs of you putting it through the letterbox with a date on or something like that, just to confirm it. I'm being quite, it's 3 examples here, but be creative. But really, we're looking for you creating evidence that it got there on time if you can. So a quick canter through all of that. It's a very discrete area, as you've seen. It's quite a complex area. Thank you for your time today, and there we are. By all means, link in with us on LinkedIn. Follow Pretty's on LinkedIn. If you've got a point you'd like to put to us, call us or email us. We are here. So thank you for your time again. And with that, I will let you get on with your day. Thank you for joining us.
Thank you. Thank you.